Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. Wednesday, February 5th, 2025 at 1:05 in the afternoon. So we're here to have a walkthrough of H-137, an act relating to the regulation of insurance product services. So we have our legislative counsel with us. Maria Royal. We also have acting commissioner from the Department of Financial Regulation, Sandy Bigglestone, and Deputy Commissioner of Insurance, Emily Brown. So thank you for joining us this afternoon, and we'll walk through and start talking about 137.
Excellent. Thank you for the introduction again, Maria Royal with the Legislative Council. And yay, it worked. So I'm going to do the walkthrough of the bill. These are all proposals that were originated with the Department of Financial Regulation. Mostly they concern insurance, but some other issues as well. And as I go through, sometimes it's helpful to hear the policy rationale for each of the proposals and to just kind of go through section by section, which is why we thought it would be helpful to do this jointly. I hope that makes sense. So with that, we will start with the very first section of the bill, section 1. And so this is in the general provisions of Title 8 and concern the regulatory authority of the Commissioner of Financial Regulation, and has very general language on confidentiality of information that the department receives. So all that is proposed here is, you'll see, I'll just begin on subsection A. This section shall apply to all persons licensed, authorized, or registered, or required to be licensed, authorized, or registered. And originally, the existing law says under this title, which is Title 8, and under Title 9, Chapter 150, which is Vermont's Uniform Securities Act, because DFR regulates investment advisors and broker-dealers by the commissioner. The issue that came up is that there are other entities in other titles. For example, Title 18, pharmacy benefit managers, Title 21, some workers' compensation self-insured. And so this is just meant to expand, not limited just to Chapter 150 of Title 9 or just Title 8, but to say any entity, regardless of what title it is. Okay, so pretty straightforward. And did I miss anything further? Clarification or questions? And then there are some other, these are more technical statutory conforming provisions. So you'll see on that line 11, I think I'm on page 2, the commissioner may, instead of his or her, the commissioner's discretion, we just have a policy to replace gendered language with non-gendered language. So the other changes in this section are simply those amendments. So that brings us to section 2 of the bill. And this is also in Title 8, and it concerns insurance companies generally, but this in the chapter, but this specific section concerns mutual insurers. And the proposed change here is also just a technical change. You'll see on line 16. So this is basically saying that they have to comply with whatever procedures might be required by the commissioner. And you'll see under section 75, which is now stricken. That's because section 75 was repealed, I think around 2014, 2015. That was general rulemaking authority for the commissioner. That general rulemaking authority is now in subsection 15A. So again, just a technical change. And all of the rules, pre-existing rules, have either been modified or updated. So there are no more existing rules under the older section 75. And that, anything else? Okay. In section 3 of the bill, so this concerns property and casualty insurance. And there are some presumptions and filing requirements with respect to the rates that insurers offer in Vermont. And so the proposed change here is just specifying with respect to the rates and any supporting information with respect to the rates that an insurance company wants to charge, rather than as currently required, that information is provided to the commissioner not later than 15 days after the effective date of the rates. The proposal here is to make sure that those filings are submitted prior to 30 days prior to the effective date, so that before they take effect, the commissioner can take action. So,
That makes sense.
Mhm.
yeah, and I think it might have been after, mostly because of the presumption that in a competitive market, the market itself regulates the rates, and but that's not always the case. So this is just an additional opportunity for the department to weigh in before they actually take effect. So section 4 of the bill, affordable housing insurance. So this section relates specifically to insurance in properties where there may be affordable housing tenants or owners of property that are subject to or receive some kind of local or federal or state assistance. And it's basically an anti-discrimination provision. So I'll just read through it, and then I will let the department speak a little bit more towards the rationale. So an insurer that issues or delivers in this state a policy of insurance covering loss of or damage to real property containing units for residential purposes or legal liability of an owner or renter of such real property shall not inquire about on an application, nor shall an insurer cancel, refuse to issue, refuse to renew, or increase the premium of a policy, or exclude, limit, restrict, or reduce coverage under a policy based on the following. And so there are, I think, 4 or 5 criteria. So these are things that you cannot inquire about. 1, whether the residential building contains dwelling units that are required to be affordable to residents at a specific income level pursuant to a statute, regulation, restrictive declaration, or regulatory agreement with a local, state, or federal government entity. 2, whether the real property owner or tenants of such residential building or the shareholders of a cooperative housing corporation receive rental assistance provided by a local, state, or federal government entity, including Section 8 federal vouchers. 3, the level or source of income of the tenants of the residential building or the shareholders of a cooperative housing corporation. Or 4, whether the residential building is owned by a limited equity cooperative, public housing agency, or cooperative housing corporation. And then I'll just finish out this proposal. Subsection B basically says, despite what I just read, if current law allows for other factors to be considered, that this in no way changes existing law. That makes sense? So if you're not specifically prohibited, or if you're specifically allowed to consider other factors, you can continue to do so, kind of a notwithstanding provision. So that's the proposal, and maybe the department wants to
Sure.
speak to, yeah.
If that's all right with the committee. So Emily Brown, Department of Financial Regulation. So essentially, as Maria said, this prevents insurers from discriminating against affordable housing, and that could be whether you're a developer of affordable housing, whether you're a receiver of affordable housing, and then also in Vermont, some of you may be aware of the emergency housing program, assistance program that we have set up for motel and hotel owners to offer their facilities to individuals who, are eligible for that program. This would also apply to them. We do believe that currently in Vermont law, unfair discrimination is not allowed in rate making. So we do believe that this type of discrimination would be unfair and not allowed. But we did think that this was a good opportunity to put it into law, make it clear that that isn't allowed in Vermont and it's prohibited. New York does have a similar law. We based our language off of that law. So if you're interested, I can circulate that too. One issue, there's actually two things I'd like to suggest or ask the committee to consider for slight adjustments to this. So originally, Maria had suggested that this language live in our unfair trade practices statute or chapter, I should say, chapter 129. And it actually ended up in this bill being put in our rate authority chapter. But what that inadvertently does is exclude surplus lines insurers from having to comply with this statute. So what the department would suggest is actually locating this section in our unfair trade practices chapter to make sure that it's very clear that it not only applies to insurers that are required to file rates with us, but also surplus lines insurers who operate in our state but are not under our rate authority.
You explain operating in the state but not being under great authority.
Yeah, so there's certain insurers, they're called surplus lines insurers, who operate in the state, but they are not subject to our requirements to file their rates with us or their policy documents. So in every state in the country, there's an admitted market, which means that it's a market where people who have normal risks can go to receive insurance coverage. So if you're you have a home or your auto and you don't pose any kind of unique risk, you're most likely getting written in the admitted market. If you are unable to acquire coverage in that market, there's what's called the surplus lines market, excess lines. And what that is a market that is available to companies, individuals who maybe their risk is unique or so high that an admitted insurer doesn't want to take that on. So there's kind of this excess market where you can go and the insurer can kind of maybe make a unique coverage option available to you that wouldn't necessarily be available in the admitted market. Does that?
For what this is describing, you're envisioning individuals who might need to be accessing that market. Did I follow that? a little bit?
Not necessarily.
Okay.
So there, for instance, if you are buying a renter's policy, it's likely that you're getting that in the admitted market, right, to protect the contents of your apartment. But let's say you're an affordable housing developer and you have several huge projects, there are unique risks depending on the building that you're maybe building or renovating. You might not be able to obtain insurance in the admitted market. So then you would go to the surplus lines market and, have a carrier there who would say, okay, I'll be able to write this, either very high amount or unique risk that they're able to kind of more tailor a product and a premium that can fit someone's needs. Yeah.
So subdivision 3 around, I was wondering, cooperative housing corporation, is that sort of a defined term or is that a particular concept? I was looking at, what is it, level of source of income. So are those corporations that are targeted or built for low-income residents, or is that a general kind of construct?
You want to speak? So that's a good question. I don't know if is your question, is it defined in statute?
Well, if it's not, is it generally understood to, what the meaning of that term is?
So again, I made reference to this being based on a New York law.
Okay.
And I'm sure a lot of you know that in New York, there are co-ops where you kind of become an owner
Okay,
of a building and everyone has a share.
all right,
And there might be qualifications to become a co-op member that might be income or occupation, you know, who, yeah. So I imagine it's getting to that type of scenario, but I can definitely get further clarification. We don't want to be putting things out there that don't make sense for our market, but I believe that's what it's meant to address.
Yeah, I totally get it in the
Okay.
concept of a New York co-op. You know, they define who's entering into the co-op kind of thing.
Yeah,
As opposed, and you don't want the insurer to be involved in that.
yes, yeah. So any more questions on the surplus lines? There was one other issue I wanted to raise to the committee for consideration.
So do we have situations like that in Vermont where we have cooperative?
I don't know. So that's what I was saying. I can look into that and make sure that it's applicable to our state. I mean, I wouldn't see why there wouldn't be a scenario where that would be allowed, but, or a possibility,
If it's possible.
yeah,
We're getting out in front of it instead of.
exactly, yeah.
Just on that, what would be the difference between like an HOA versus a cooperative? Or is that just a governance structure?
I'm not sure. So
Okay.
that's way outside of my
Okay.
expertise or lane, but I can definitely, you know,
Yeah, I guess
look into that and talk to someone in housing.
Yeah,
to
that's what I'm
understand
asking
that.
is like, would
Yeah.
the
Yeah.
co-op thing cover the
No, I get
HOA,
it.
which we
Right.
have?
A lot of, right,
Yes.
yeah, understood.
I don't know, but it's more of clarification between the HOA and the co-op, being realtor.
Oh, there we go.
A co-op, we do have them, is a situation where it's everyone owns a share. You see this a lot in mobile home parks. The one that we were talking about today in TIF, that mobile home park is a co-op. An HOA is a little different in that it's designed to deal with common area issues. Maintaining the roads. If you've got 8 units all under one building, you're gonna have, the roof's gonna need to be taken care of. So I just wanted to get a little clarification from them.
But I would think even under that scenario, the parents that they have to obtain the HOA has.
Correct.
Right, yeah. Great. So the one other item I wanted to bring to the committee's attention is there is an insurer out there who serves this market of affordable housing. So what we inadvertently did is not allow them to serve, they only serve affordable housing essentially. And what we have done with this language is not allow them to ask about affordable housing to then write these businesses. So there's 2 ways that you could go about adjusting the language to make sure that those types of insurers are allowed to operate. You could remove the prohibition on inquiring. So you could allow an insurer to still inquire, but that doesn't mean that they can then underwrite or rate on the basis of it being, under the criteria that Maria ran through. Or you could additionally put some language in there that says, an insurer who only offers coverage for affordable housing, entities or, persons as defined in the statute is exempt from inquiring. I think I prefer the elimination of inquire. And the reason being is that when we actually went to the market and surveyed insurers on this, most of, I would say, close to all insurers who we asked about this do not collect data on whether they're serving an entity that provides affordable housing or not. And because the reason being is that they don't want that information because that could then lead to having that knowledge and then, being able to have to prove a negative, right? That you're not using that information for rate making and underwriting. So generally we found that insurers are not collecting this information. They weren't even able to tell us which hotels or motels were serving affordable housing versus not. So I kind of think the cleaner option is to just eliminate the prohibition on inquiring. But that's the department's preference and obviously defer to the committee on that, on how you'd like to see that in the statute.
Everyone good with just moving the inquiry?
Back to you.
That brings us to section 5 of the bill. And this and some of the subsequent sections pertain mostly to captive insurance. I believe you got a nice presentation and background on the captive insurance industry in Vermont, and what they are essentially, usually wholly owned subsidiaries that self-insure parent company or affiliates, right? So this first section 5 pertain to the licensing authority or the licensing of captive insurance companies. And the change here, you'll see on the top of page 6, they are required to get a license. And the proposed language is to conduct insurance business comprised in, and the proposal is to just specify section 3301 of Title 8. What is in current law are specific subdivisions of 3301. And I think the only things that were not included, and I stand to be corrected if I'm wrong, in 3301 were workers' comp, multiple lines insurance, and inland marine insurance. Everything else is already identified here by specific subdivision. So this would just say any of the insurance that's authorized in Vermont, essentially, without any exceptions. But fair.
Sandy Bigglestone, Acting Commissioner, DFR, and also Deputy Commissioner of the Captive Insurance Division. Just for a little bit more clarity, we found, that there are many instances where the captive insurance statute points to the traditional insurance code when it makes sense. And so we found that the references in the captive statute to section 3301 could be improved simply to just reference 3301. And, there are, there's really no risk to doing that, only because it's hard to sort of look through those subsections and start to decipher what's allowed, what isn't allowed, when in fact, 6002 in particular, under subsection A, there are, it does serve to limit the scope of certain types of coverage that a captive can transact. And so, for instance, 602A1 states that no pure captive may insure any risks other than those of the parent and affiliated companies or controlled unaffiliated companies. 602A6 states that no captive insurance company may provide personal motor vehicle or homeowners insurance coverage or any component thereof. And then there are a few other sections. So we can still limit what we need to. And I think that just simply referencing 3301 makes a lot of sense. Happy to take questions.
Okay.
So the, in your 6,000 captive insurance, you're saying there are limitations on the lines.
There are limitations.
So really just. So you're eliminating the limitations on your lines in the general statute, but you still have them in that.
We're basically saying any insurable risk that an insurance company or reinsurance company can undertake can be done in a captive. And then 602 goes on to limit that scope to, to prohibit homeowners, personal auto, things that don't belong in a captive.
Thank you. I'm making sure I understand then. Rather than have gaps in what one can do around it, like let's get a tent under which then we find. So there's just, I think that might not be the right visual, but I think I'm understanding that there's spaces that 602 sort of says yes or no to specific things, and you have to keep working through that.
Yeah, at times, yeah.
At times.
And so there may be something that, in in prior statute or as current statute, that is allowable, that could be put into a captive, but we're kind of hamstrung. And then 602 becomes difficult to, under our licenses authority to interpret at times.
Okay. So that brings us to section 6 of the bill. Also in the captive insurance industry, and this pertains to the minimum capital and surplus requirements that apply to captive companies. And the change here is, you'll see in this subsection D, it says within 30 days of commencing business, each captive insurance company shall file with the commissioner a statement under oath of its president and secretary. And the proposal here is to add or 2 individuals authorized by the governing board, certifying that the captive insurance company possessed the requisite unimpaired paid-in capital and surplus prior to commencing business. And I will let the department speak to that. I'm just going to mention, you'll see there are several other sections that make a similar change, where instead of there are specific individuals referenced, it's broader authority to anybody, to any 2 individuals that the governing board authorizes to verify under oath. So again, that's going to come up in other sections as well, but
That's it. So this doesn't, this amendment doesn't change the substance of this and of this section of our statute, as well as the other sections Maria was pointing to, and you'll see as we go along. What this is aimed to do is to clarify related to signing authority of individuals in a manager managed limited liability company. So 606 sets out the requirements for the formation of captive insurance companies. And that is also pursuant to general corporate law. So Title 11, Chapter 25 pertains to limited liability companies and allows for the LLC to be manager managed rather than member managed. These are corporate law nuances. And so in a manager managed limited liability company, the operating agreement expressly provides that the company will be managed by managers. Managers have the exclusive authority to manage and conduct the company's activities. So the operating agreement governs LLCs where managers act like officers of a corporation, but are not named officers in the corporate sense. So really, there are various sections throughout this bill that are adding language to where you see president and secretary or named officers of a corporation, to add language simply to say individuals authorized by the governing board, so that limited liability companies are not, there's no gap created because of LLC structures.
okay, so that brings us to section 7, which pertains to section 6006 of Title 8, having to do with formation of captive insurance companies. And this is just really a technical correction. You'll see on line 15 a reference to chapter 21 of Title 11. This applies to captives that are formed as limited liability companies. In, I think, 2015, you repealed that chapter and created a new chapter, chapter 25. So you're just, this is a conforming change to reflect reorganization of statutes. And that just occurs in a couple of other places in that particular section. And then there's a new provision, which is in subdivision 3, and this is, of subsection I. And so this just specifies that under existing law, if you're formed as a limited liability company, you have to comply with Vermont laws. that pertain to limited liability companies, hence the reference to new chapter 25, or the updated reference. A similar provision under existing law for nonprofit corporations, you have to comply with nonprofit law. So the new subsection here is specific to mutual insurers, basically saying that you have to comply with Title 8 as it pertains specifically to mutual insurance companies. And then, as in the prior sections, in the event of a conflict between the general law and this law, captive law, the provisions of the captive's law shall control.
So I take it, those are the only two sections that you want to have this crossover between captive law and mutual
Mhm.
rights. So there are a bunch of other things, but these are the only two that you want to have that
Yeah, in practice,
correlation.
we, when licensing new companies, if they're formed as mutuals, we always look at, 3311 and 3303. And we apply those. And what was discovered this year was that, the specific references to those mutual insurers, was missing in our law. So again, just making this part of our statute more complete. And just to be more specific, 3303 addresses the governance standards of mutual insurers for election of officers and how meetings of policyholders will be held. And then 3311 addresses quorum requirements. Again, we follow all of the laws that we need to, but this makes our statute more complete by including this language.
Thank you.
And I just wanted to bring up one point, and you don't have to go back, Maria, but, Emily, when we were talking about, pieces where making sure that insurers aren't discriminating because of Section 8 housing and all that. We're not adding that language because of issues that we're having. It's just to clarify what is already in statute, not to make it plainer that they can't do those things.
Yes, and in full transparency, this was brought there, this was specifically brought to the department as a potential issue that, some participants in the emergency housing program were, so I'll just back up. So generally, right now, the insurance market is called a hard market, and we've talked in this committee about that, right? Everyone's premium is going up, costs are rising, reinsurance is being hard, it's harder to procure and more expensive. So a lot of hotel motel owners who are participating in the program were either seeing maybe their coverage, their premium increase, or were being dropped. That's what we heard from some participants. So there was a concern that that was happening because of participation in the program. And we are currently, we've sent out a survey to all the participants in the program to make sure that this isn't happening. There were, I want to say, 2 instances where we had questions for the insurer as to the reasons why they canceled the insurance policy of that particular hotel or motel. But generally, when we surveyed the market beyond just the emergency housing program, also when we talked to insurance companies about how they treated affordable housing, again, a lot of them said, we don't know who, we don't collect that data because it's not part of our underwriting or rating process. We're rating on whether the building, is appropriately kept up and has the right wiring and, it's up to code. So that was what we heard, not regarding the status as affordable housing. Yep. Thanks for adding that clarification.
So that brings us to section 8. And this section has to do with mergers within the captive insurance industry. They are required to comply with the general merger law that applies to insurance companies, which is that reference on line 20, subdivision 6006J1. But then there are also specific procedures related to the merger of captives, having to do with adopting a resolution, what that process is, approving the agreement of merger, And I'm just getting down because in the process, the substantive change that's proposed here has to do with the articles, the adoption of the articles of merger. And this is one of those other instances where the authority or signing off on the articles is broadened. So you'll see beginning on line 18, the articles of merger shall be signed on behalf of each insurer by a duly authorized officer or individual authorized by the governing board. Again, broadening beyond just named officers. And that is the only substantive change in that section. All the others are, technical changes about having to do with non-gendered language.
This is to make sure we're including that manager managed limited liability company.
So then, similarly, in section 9, this has to do with reports and filings of captives with the department. And you will see on page 14, the report of a company's financial condition. Again, verified by both of its executive officers or 2 individuals authorized by the governing board. I think there are like another 3 of those. Oh, and the other substantive provision comes at the end of that section and specifies that subdivision 6002C3, which pertains to confidentiality provisions of this title, shall apply to each report filed pursuant to this section, except that such subdivision shall not apply to reports filed by risk retention groups.
And that is just to make clear that, that was an update to make clear that risk retention groups file under NAIC requirements, and they are subject to public disclosure. So we want to make sure we get that clarification in there.
They're not trying to. So they're not under 2 different requirements.
Right, and in chapter 142, general captive provisions are in 141. Chapter 142 pertains to risk retention groups. And it's clarified in there that they shall file with the NAIC, and those are subject to public disclosure. So this was a important catch to make sure it doesn't conflict.
Okay, ready for section 10? So this pertains to captives that provide reinsurance. And what this is doing is specifying that any captive insurance company may provide reinsurance of policies approved by the commissioner, comprised in, and you'll see the reference there, this is a section we talked about earlier, section 3301, which is the different types of insurance that are allowed in Vermont generally, of this title, on risks of its parent, affiliated companies, and controlled unaffiliated business ceded by any other insurer, and may provide reinsurance of annuity contracts, et cetera.
And just a little bit more clarification on the process for making these amendments. We believe that it'll provide more consistency between sections and avoid confusion as to what's allowed on a direct insurance basis under 602 and what is allowed on a reinsurance basis by captive insurers. So it'll definitely align in the proposed amendments to simply point to section 3301 in section 5 of this bill. This also helps to align with that a little bit better.
Sorry, I know I don't want to ask something that's already been asked, but when we talk about the controlled unaffiliated businesses, can you talk a little bit more about what that could be?
Sure, there's a section of our statute that allows for a captive insurance company to enter into transactions for controlled unaffiliated business. And if you think about an organization, a corporation that owns a captive, they may have a contractual relationship with a vendor, or we consider employee benefits to be controlled unaffiliated business because they are employees of the corporation, but they're third parties. So we want to be able to distinguish third-party relationships between the owner of a captive, and if there's some exclusive vendor relationship or something where they can extend the insurance coverage of the captive to that entity, but have some control over protocols relating to risk management and risk mitigation. That is something that we have allowed and want to continue to allow. This particular statute is for reinsurance. So reinsurance is insurance for insurance companies. And we want to make sure, and then reinsurance also pertains to where a captive insurance company is, we call them fronting arrangements, but they act as a reinsurer, and they will transact a reinsurance agreement with a commercial insurance carrier. But it's the risk coming into the captive should be limited in scope to the risk of the owner of the captive. So this kind of sets that tone a little bit better.
Okay, moving on to section 11. This section pertains to captive companies that go into a dormant status. It has to do with what requirements apply in that period of dormancy, and the only substantive change is that language that we've seen already. Instead of verified by oath of two of its executive officers or individuals authorized by its governing board. And similarly, in section 12, again, this is specific to branch captive insurance companies, and more specifically reports that they are required to file with the commissioner, and similar broadening of authority of who can verify by oath.
So I've noticed here we're talking about two executive officers. Are we talking about two individuals, or is? Because I've noticed before, we're talking about, we're saying or two individuals, or if it's only one person, but here we're not saying.
Oh, good catch. Yes, it should be
should
two
be two.
individuals.
Yeah,
Thank you.
excellent. Yeah. And section 13, similar change as pertains to special purpose financial insurance companies. In this instance, it's just one officer or an individual. And then section 14, this is specific to risk retention groups, which the commissioner mentioned are governed in a different chapter of Title 8. And this particular section has to do with the governance standards that apply to risk retention groups. So changes to gendered language. Okay, sorry, just had to remind myself here. So with respect to the governance standards, there is a definition of what's considered an independent director. There are requirements about having independent directors. And so under existing law, an independent director means somebody who does not have a material relationship with the risk retention group. And then it goes on to specify what constitutes a material relationship with a risk retention group. And I think this is just more of a technical correction. This was I remember working on this. this was a really complicated outlining initiative. And so the way it's written now, and I'll just explain the difference with current law. So you'll see that first Roman numeral 1. So again, these are people who would have a material relationship. So individuals that in any 12-month period received from the risk retention group, et cetera, compensation. I'm not going to go through all of it. Then in Roman numeral 2 on line 19, you're have a material relationship if you have a relationship with an auditor as follows. And then all of those provisions. And then this third one, which is now, and I believe it was intended to be a separate third definition of what constitutes material relationship. The way it was outlined, though, you can see it was AA. It looked like it was a subdivision of the prior, right? So this is just changing the outlining. So now it's its own separate category. You have a material relationship if you're employed as an executive officer of another business that's affiliated with the risk retention group. So I believe that's consistent with maybe what the original intent of the model language was. And the rest of that's just outlining to conform with that change. So, and then specific to risk retention groups with that authorizing language, the president, chief executive officer, or individual authorized by the board of directors of a risk retention group. And that is it. Section 15 just specifies that the act takes effect on passage.
Emily Brown, DFR. I do have one other issue I wanted to raise with the effective date. So section 3, which was the change from the 15 days to the 30 days for our rate filing. Because companies plan several months in advance on rate filings, I think the department would just request that there's a date certain. So it could be July 1 or whatever date the committee prefers, but so that there is a known date when insurers have to switch over to this new filing process. So that was the other request that we would have for an adjustment.
It seems like July 1 is.
Yeah, that's
That
good.
we usually use, so.
Yeah.
Do you want that to be the default for the whole bill or just for that section 3 that Emily was talking about, or?
Yeah, I would, if it simplifies things for the committee, July 1, there's nothing in the captive sections that would need to be effective upon passage, and July 1 would be just fine.
So we have those, you have all the changes, Maria, that so far.
I've received some proposed amendments. I can let the department speak to those.
Well, I think it's
Or do you-
one of the changes now that the
Oh, the ones that just came
Yes.
up here.
Mhm.
Yeah, I think so. I'll confirm though.
Yeah.
Make sure I got everything.
And we will have Aaron, and I think there's a proposal from Rocket Mortgage. You're aware of that, Sandy?
Yes.
So we'll have them in next week, I think, and chat about that. Then I think Emily can talk with Jen Carby.
Yes.
See if we can get that worked out, figured out. And then, are there any other amendments or those are the only ones that I'm aware of? Are there any other?
I think there were some others floating around, but maybe I'll check in with
Yeah.
you and just confirm.
Yeah, we'll have that discussion tomorrow first. We got to hear from Aaron on that as well, on the crypto report. Okay, so I think we can now jump to Kevin from BCIA. I believe that Kevin is on Zoom if you want. Can you give us a screen back, Maria?
Yes. Over here. All right.
Thanks, Mr. Chairman.
Hi,
Kevin
Kevin.
Mead, Kevin Mead of the VCIA. Seeing me on the large screen, you might prefer to have seen the bill rather than me being large in front of you, but there you have it. I just wanted to give you sort of 30 seconds background on industry support for the captive elements present in the changes that you are currently discussing, and to give you just a brief insight into how the process works. Around every August, we gather together folks connected with the captive industry to talk about what the asks might be in terms of potential changes to the captive enabling legislation. And as you can see from the content of this bill, there are not many changes of substance that are there, but we do discuss those, and then we enter into a discussion with the DFR as to the things that are attainable and the things that are not attainable, because as you might imagine, industry occasionally wants to spread its wings somewhat, and there are some certain underlying core principles that the DFR then reins us back in slightly with those. But we go through that process in order to ensure that industry's wishes, concerns are being raised. And then as the bill is being drafted, we then have a legislative committee within the VCIA that consists of about 33 people from industry who take a look at that, and we get walked through that bill in order to ensure that industry is aware of the changes that are being proposed and is able to make its voice heard. So with that as background, I'm appearing before you again just to express the support of industry for the bill that you have seen, or the changes to the bills that you've seen in front of you related to the captive industry, and that we remain confident that this will present a unified and effective framework for that industry to operate and grow within the state of Vermont.
Thank you, Kevin. Any questions for Kevin? Okay. Thank you, Kevin. Just to let you know, we had the Vermont Lodging Association in this morning, and we're talking about BCIA and the need for a convention center and that type of thing. And so we're talking anyway.
Thank you, Mr. Chairman. And by way of additional information, I was at a meeting of New England-based associations in Massachusetts last week, where the New England Water Association also expressed an interest in having better infrastructure for meetings within Vermont in order to be able to bring their regional New England water meetings into Vermont as well. So there's a groundswell coming from my side as well.
Yeah, great. What we need. Any questions? No. Okay, Kevin, thank you for joining us.
Thanks, Mr. Chairman. Thanks, everybody.
Amy.
Thanks, Mr. Chairman, members of the committee. By way of introduction, my name is Jamie Fian. I am the Government Relations Director for the Burlington firm Primer, Piper, Eggleston, and Kramer. I work with a number of entities and companies that have interest in the issues you all consider, so I look forward to working with you where we can over the session. One of those entities I'm here on behalf of this afternoon is the American Property and Casualty Insurance Association. APCIA is the preeminent national association of, you guessed it, P&C companies, writing virtually all lines of property casualty, from auto to homeowners to commercial lines, liability, auto, workers' compensation. I won't name them all, but they comprise nationally of over 1,000 members, but several hundred of those are licensed to do business here in Vermont. The department was kind to share with APCIA, as they always do, and others in the industry prior to you all getting together, what is comprised of their legislative agenda, and they were able to do that again this past late fall, early winter. It was a conceptual, at that time, so we didn't see the specific language until recently. So our focus with the department and the conversations have largely been around, clarifying intent, and some of the issues that you've already addressed. I'll just express support and readdress. I mean, I would characterize the amendments as clarifying this year. I'm only speaking to sections 3 and 4. These are the traditional insurance ones. The others that you went through are all captive insurance related and don't impact APCIA. The rate filing, having clarity on the effective date was important for us to make sure it was prospective and wouldn't, for the reasons stated, but also to not impact any filings that are currently, in the process. The affordable housing piece, again, while there is sort of a blanket prohibition already in statute on, it's a violation of insurance trade practices for insurers to have unfair discrimination in underwriting or to make arbitrary decisions based on underwriting. But the department in this case feels that clarifying or calling out this particular instance is needed. We did our own internal surveys in addition to the department, our folks collecting this, and I can similarly report that that's not information that is being collected at this time. So while in some instances I may be before you resisting, efforts to kind of address underwriting tools, in this case, that doesn't necessarily need to be the case. Similarly, we would support the amendment that you made to allow insurers whose core business and sole business is insuring affordable housing projects, complexes. And it's actually, the one company mentioned, I'm sure there are probably some others. It's a good story started as a Vermont captive risk retention group that insures public housing projects in New York, New Jersey, and regionally. And they converted to be a Vermont traditional insurer to continue this line of business. So the amendment that you approved will allow them to continue to, they participate in federal, housing programs. And my understanding is compliance and eligibility are factors that they have to comply with on their end. So that change you made, I believe will do it. If there's anything additional, I'll bring that back to the committee if you'll permit me. Second piece, similarly, if I could kind of take back and share with respect to having it apply to surplus lines, we assumed it would not apply to surplus lines. So the proposal to do the opposite is something I'd like to flesh out a little bit further. The non-admitted or surplus lines market is, often looked at as the option of last resort for individuals or companies that are looking to find coverage that may be difficult in a traditional market. As it's a non-admitted market, it is, sort of has a lighter regulatory touch. So in a general sense, we try to keep that, my word, as pure as possible as an option of last resort, and regulatory efforts to kind of bring them under the traditional fold sometimes, seems to be opposite of that goal. So I'm not saying this is an issue. I'd just like a chance to perhaps bounce it off folks and see if they've had any issues in New York, for example, or because I don't think there are any other states that I've been aware of where this has popped up. And my understanding is with respect to the rate piece, the department will be developing a bulletin to provide some additional guidance as this unfolds, and we look forward to working with them to address any other implementation issues.
Questions?
Sorry, I couldn't offer more today.
All right. I think that's all we have for this right now. Maria will draft those amendments. I'm going to set it up for next week. To go through the amendments. We'll hear from Aaron tomorrow on the crypto report that was done by the department, and make a decision tomorrow what we do with that. And we'll take this bill up again next week. We will take a look at H124 as well before we finish up on 127 to see if we incorporate that in there. And so we'll ask you, we'll be in touch let you know when we're gonna take these up and we set it up for Wednesday, possibly. But we'll finalize that by the end of the week and we'll be in touch. So I think that's all I have. We're on the floor at 3. We'd be on the floor, we have the first bill that's coming up today. The vice chair will be presenting that bill. And then we're back here at 9 tomorrow morning, so. I ate up 15 minutes and now I'm giving you 50, 55. Doesn't seem fair to me.